I think that illustrates the problem of establishing what are facts. First of all, I'd like to start by thanking the organisers for inviting me and for getting me to consider, yet again, the interesting question of fact-finding. This isn't simply, now let's denounce Goldstone. I'm perfectly capable of doing a let's now denounce Goldstone, but this isn't what I'm going to do, nor am I, as such, reviewing the book that is the reason that we're gathered here this evening. It's rather a response to some of the issues that the book raises in the context of my own very varied experience of fact-finding. I hope along the way to give the panel something into which to get their teeth. Knowing that Rob is in the audience, I am confident that he will be able to get his teeth into this. A very good book was produced in the 1980s, in fact, published by Nijhoff. I've just been suggesting to Lindy Melman that she might want to look at reissuing it, that concerned fact-finding by NGOs. In some ways, that was an easier environment in which to fact-find. It was fact-finding in the Cold War, where Western NGOs knew what they were for, and there was a limited range of law that they were using. The situation we're dealing with now is more complicated. The English are good at coming up with contradictory aphorisms or sayings. For example, we hear that many hands make light work, and that isn't a reference to electricity, but equally too many cooks spoil the broth. I think in this context we've got two conflicting aphorisms again. One is, if a job's worth doing, it's worth doing well. Anybody brought up by English-speaking parents just groans at the idea of that. So a job worth doing is worth doing well, but equally, don't let the best be the enemy of the good. There is a real risk when one looks at how to address the problem of the quality of NGO fact-finding, that you may end up delegitimizing, a term you'll be used to here, delegitimizing NGO activities, and that isn't the goal. The goal is to improve them, not to delegitimize them. So the question is, can fact-finding be improved? The answer to that is yes. It's certainly not perfect. But maybe the question is it good enough, rather than is it perfect? And I'll come back to the question of a way forward at the end. I want to look briefly at four issues. First, who is doing the fact-finding and what for? Second, the relationship between fact-finding and law, because I think it's more complicated than is usually recognised. Third, the quite horrible challenges involved in trying to fact-find during or about situations of armed conflict. There are particular challenges there. And finally, whether one needs guidelines or minimum standards for NGO reports. So the first thing is, who's doing it, in what context, and what for? Here, there are a huge number of independent variables, and this is going to have an effect when one considers what one should do about the quality of reports. First, as far as who's doing it is concerned, and in what context, you can get fact-finding as part of judicial proceedings. Even limiting myself to the international level, there's fact-finding for the purposes of criminal proceedings and fact-finding for the purposes of civil proceedings, and there's a huge difference between the two. Let me give you an example. I was sent to the former Yugoslavia by the International League of Human Rights, a US-based international NGO, and they wanted evidence about what was going on in northwestern Bosnia, that's the villages that were being ethnically cleansed. This was before the creation of the ICTY, but after the establishment of the Commission of Experts. So I was aware of the fact that there might conceivably be criminal proceedings. This affected how I interviewed possible witnesses where their evidence might be relevant in criminal proceedings. Because instead of something like half an hour, which might be sufficient with a human rights case, no witness was interviewed for less than 2.5 or 3 hours. That meant that to do a decent number of interviews, you had to be working 22 hours a day, and you can't keep that up for all that long. It also drove my interpreter up the wall. So the context in which the fact-finding is occurring affects the fact-finding. That was in the context of judicial proceedings. There's also fact-finding by intergovernmental organisations where it's more of a quasi-judicial type, there I would consider that some of the commissions of inquiry set up by the Human Rights Council are quasi-judicial rather than judicial. And no, I'm not referring to Goldstone. There's a very interesting, more recent one that can be usefully compared to the Goldstone report, and that's the Bassiouni report on Lebanon, where they had got cooperation from NATO, and it's interesting to see how they set about carrying out their job. I would distinguish yet again the work done by the thematic special rapporteurs, in that they're not technically fact-finding, but when they are carrying out country visits or when they're handling individual cases, they are having to evaluate factual material. So I'm not sure whether they would see themselves as fulfilling a quasi-judicial role or whether anybody else thinks they're fulfilling that. And then, of course, there are NGOs. NGOs vary enormously, even amongst, even I'm taking it as given that I'm limiting myself for the most part to human rights NGOs. You can get issue-specific NGOs. You can get victim group-specific NGOs, for example, ones working with the Roma. You can get country-specific NGOs. The minority of NGOs deal with situations internationally or regionally and across the board. So Amnesty and Human Rights Watch are not typical of the majority of NGOs. I don't think it's relevant to fact-finding and the integrity of a fact-finding report to ask oneself whether an NGO is being even-handed in a choice of situations that it investigates. It may be a relevant issue to raise. For example, if you get NGOs producing 10 times the number of reports on State A than they report on State B. But I don't think it necessarily means that any resultant report is tainted by preoccupation with a particular situation. I also think one needs to be careful before we blame NGOs for only dealing with state accountability and not the accountability of non-state actors, because non-state actors aren't legally bound by human rights law, even though they are bound by the law of armed conflict. But you can even get, to take an extreme example, fact-finding by a very peculiar kind of NGO. Imagine a political party in the run-up to an election. It knows that there is a problem in a certain area that it wants to raise because it wants to beat the government about the head. And it wants to find an example of it. We had this about 20 years ago in the UK with what became known as the Battle of Jennifer's Ear. It was about the length of time you had to wait for NHS appointments. And they managed to find a young girl, because it helps when it's a child victim, and they managed to find someone who fitted the bill where they were looking to fit the bill. But in a sense, they were taking a set of facts. They started out with knowing what they were looking for, but that's still a form of fact-finding. Now, it's not what you're thinking about when you consider fact-finding by human rights NGOs, but you've got to bear in mind the extraordinary range of situations in which even non-governmental organisations that themselves are extraordinarily varied are actually engaged in fact-finding in. You also need to ask yourself, or the NGO does, what is it doing the fact-finding for? Is it fact-finding for advocacy, or is it fact-finding for accountability? If you are seeking to gather facts in order to advocate for a cause that you espouse, then that's going to affect how you set about fact-finding and what your report and what you do with the report, as compared to an NGO that is seeking to gather facts in order then to call a government, usually, to account for alleged violations. So that's something on the range of NGOs. There's also a huge range of functions that NGO reports may serve. So within one particular NGO, it may produce reports for different purposes. One could be to sound an alarm. NGOs, and they weren't alone, this was also true of special procedures, sounded alarms in 1993 and early 1994 with regard to the situation in Rwanda. Now, the function of a report sounding an alarm isn't the same as the function of other NGO reports. An NGO may also seek to nip a problem in the bud. So where a problem has already arisen, It may want to prevent it getting worse, or it may want a speedy response. In which case, and this often arises during armed conflicts, the thing that matters most is the speed of response. If you're doing something fast, you're not going to be able to do it in the same way as if you're doing something that is much more considered. It's going to affect where you go, it's going to affect the number of people you see, it's going to affect the time you will spend on it, and so on. So you've got a range of completely legitimate different functions that the same NGO might want to discharge through its reporting system. And it's going to affect how they fact find and the contents of their report. For example, it will affect whether you engage in individual interviews to look at individual incidents, or whether you engage in mapping. You can't engage in mapping human rights violations if what you're trying to do is do something in the short term as a matter of urgency. Also, if the nature of what you're trying to do is to raise specific alleged violations, if they're trying to get at the conduct that caused the alleged violation, then you're more likely to want individual incidents than mapping. Where mapping is very useful is where you're looking at remedial mechanisms. So it's going to have an effect on how you do the fact-finding, and it's completely appropriate that it should have that effect. Another contrast, depending on the function of the report, is whether you only deal with direct testimony or whether you also use the reports of other organisations. There are occasions when it's either necessary or thought desirable for a group to essentially use only the massive reports available out there. That's still a form of fact-finding. It's not necessarily illegitimate on condition that it makes it clear that the fact-finders have not in fact interviewed anybody, or that they've interviewed people with secondary information as the authors of reports. All these issues suggest to me that there's an extraordinary range of variables and different types of variables that mean it's going to be extremely difficult to come up with something that meets all the needs in all the situations. Obviously, one of the key questions is, to what extent does an NGO need and value credibility? Because the quality of the fact-finding will affect the degree to which a report is seen as credible, or it does generally. Given the example that Ilan raised of the Netherlands, I think it's worth remembering the number of people in the Netherlands who are members of Amnesty. I think, in effect, the Dutch government is a branch of Amnesty, and where you've got a culture that's so human rights orientated, then I think there is going to be an assumption which can usefully be challenged as to the value of any and every human rights report. They're only as good as the individual report is, but I think in some cultures it's not surprising that you get that issue. So the issue of credibility will matter a lot to certain NGOs, but not necessarily to all. They may want their credibility with their own constituents, in which case getting into some good denouncing may make it much more credible than something that's more considered. If the people in relation to whom you want credibility are third governments, not necessarily the alleged perpetrator, then you need to appear to be considered, etc. So again, even the issue of credibility is, I think, more complicated than we often accept. So that's the first issue of who's doing it and what are they doing it for. What about fact-finding and the law? You'll see that it's sometimes suggested that you should completely separate the issue of finding facts from any discussion of the law that applies to those facts. I don't think it is possible to distinguish the fact-gathering from the actual some use of the law as part of that process. You can't leave it to others to do the evaluation, because you only know what is relevant in the way of a fact by having some sort of legal norm that is determining what's relevant. For example, the colour of the dress of a victim of torture is not relevant to whether that person has been tortured. Therefore, it's not a fact that needs to be included. In case there are journalists present, the age, particularly of female victims, is also not relevant unless it's something to do with the child and you're dealing with the Convention on the Rights of the Child. So that doesn't need to be in a report. But exactly what happened to them when, whether they were blindfolded, etc., that's relevant, but you only know it's relevant because you're aware of the legal norm in the light of which you are gathering the facts. So I don't think that you can completely separate facts from the law, but that does give rise to a problem that those gathering the facts need to be aware of. They have a norm in mind. They think, I am looking here at torture, or I am looking here at arbitrary killings or arbitrary detention. And they're gathering facts in the light of it. They need to be very conscious of when they have got a hard-boiled fact and when they're interpreting a fact. They need to be conscious of the difference between a legal norm and the interpretation of the legal norm. I think one of the reasons that many NGOs come up with conclusions that, in my view, aren't justifiable, isn't that their facts are wrong, it's that their interpretation of the law is wrong, partly because they're taking a human rights approach to what is the law of armed conflict. For example, if you assume that there is a cast iron legal obligation to give a warning in a very specific form before you attack a building under the law of armed conflict, you are going to criticise what Israel does. On the other hand, if you actually paid any attention to what the law requires, you take the view of the majority of Europeans and North American states, which criticise Israel for doing too much in the way of warning because you're upping the standard and they don't want to have to be bound by the Israeli standards with regard to warnings. So take your pick. But I think the problem is arising not because they don't know which norm to cite, but because of the way that some of the fact-finders are interpreting the law. And it's not a problem with fact-finding, it's a problem with the interpretation of the law. So the first point is I don't think you can separate fact-finding from taking account of the law. The second issue is the law through the prism of which you're interpreting the facts. Now here I'm making a much more specific point about a specific kind of fact-finding, not fact-finding generally. I'm talking very specifically about fact-finding during or as a result of situations of armed conflict, where the norms being applied will be a mixture of human rights law and the law of armed conflict. What is not recognised by the majority of commentators, including some who ought to know better, is that part of the law of armed conflicts does not function in the same way as human rights law, and this has got a knock-on effect on how you handle the law for the purposes of fact-finding. I'm going to proceed by way of sweeping generalisation here. I know that there are exceptions to this, but most of human rights law and most of the Geneva bit of the law of armed conflict, the proper international humanitarian law bit, the stuff on the protection of victims, most of it works by prohibiting results. If you prohibit a result, e.g. if you prohibit torture, then you can proceed by simply interviewing the alleged victim, seeing what happened to them. You do need to make sure it happened at the hands of the state or state agents. But you don't need to look what was in the mind of the torturer. Because the thing is, torture is not supposed to happen. If you've got a large number of prisoners of war who in a prisoner of war camp end up dead, then there is a prima facie case. I'm not saying there's a conclusion, but given the scope of the responsibility of the state running the prisoner of war camp, the very fact that you've got a significant number of dead prisoners of war raises all sorts of issues. You may even be able to go so far as to presume some sort of form of unlawful conduct, but not actually convict anybody on that basis. But the Hague law part of the law of armed conflicts, the stuff on means and methods of warfare, is constructed very differently. It's not based on a prohibited result, apart from in the case of the intentional killing of civilians. It's based on avoiding a result, and the means it chooses to avoid the result is by addressing the mind of the attacker. It says, these are the things you need to take into account. You therefore cannot reach a conclusion as to whether there has been a violation of Hague law without knowing what it was that the attacker knew or ought to have known or thought, possibly wrongly, that he did know. So you cannot reach a conclusion, in my view, with regard to the commission of war crimes when you're talking about Hague law, unless you've had a certain measure of cooperation with the attacking state. You can say, we have a real concern about the attack in such and such a place, we don't see that there was any military objective in the vicinity, for example, but what you can't do is say it was a war crime, because you might not know what they were attacking, but the people whose conduct you're trying to investigate, you don't know what they knew if they haven't cooperated. You don't know what possibly wrongly they thought they knew. So the very special way in which Hague law functions, as compared to human rights law, it seems to me has a knock-on effect on fact-finding, and I don't think this is sufficiently taken into account, both by NGOs and also by IGOs. That's one of my big gripes about Goldstone. It's the reaching of conclusions where, and he can't say, oh, I didn't, you know, if I'd known then what I knew now. He knew what he didn't know. He knew that they didn't know why they attacked a building, in which case he can say we've got a concern. What he can't say is it's a war crime. So that issue is very particular to fact-finding in this context. The third point I wanted to look at was challenges when you're fact-finding, practical challenges, when you're fact-finding during the course of an armed conflict or when you're dealing with conduct in an armed conflict, so after the event. Obviously, the problem when you're trying to investigate at the time, which is what you'll be doing if you're trying to sound alarm bells or trying to respond speedily to something that's happening, there's the need for speed, there's the volatility of the situation, and you are probably not going to have access to the place where the things are happening. A second challenge is what information do you rely on? Do you only rely on direct evidence from victims, in which case how do you get hold of them? Or can you also rely on reports from others, particularly national NGOs? And that one needs to be sorted out. There's obviously an issue of access to the places, both at the time and conceivably subsequently. Access at the time can be limited because there's fighting, but even afterwards there can be limited access either on spurious grounds invoked by one party or another, or genuinely because of the danger of being in a place, particularly if there's a large number of landmines. Then there's all the practical challenges of dealing with witnesses when what you're taking is evidence concerning a conflict. First of all, you need to protect a witness, which in the majority of circumstances means you mustn't identify them. The suggestion that because of the needs of transparency, it means you should identify your witnesses. I can't think of a better way of ending up with an awful lot of dead witnesses, particularly in armed conflict situations. There's also huge challenges with how you interview witnesses, particularly if they've been through a traumatic event. You want to avoid re-traumatizing them. Now, when you are interviewing for the purposes of criminal proceedings, I think it's probably not possible to avoid it, because you don't just want to know what is it that you suffered, you're trying to see were they identifying insignia, how did they know who it was who was doing what they were doing to them, and that means you require them to relive the experience. The time in my professional life I have felt more sordid was when taking a victim of torture in detention, doing the examination in chief before the European Commission of Human Rights when it was fact-finding. She was traumatised by that experience. She'd already been significantly traumatised by what had happened before then. It would have been worse if I hadn't done it, because the government would then have cross-examined her in a much tougher fashion. But in addition to her being traumatised by it, I felt sordid. So, I mean, sometimes you can't avoid it, but thinking about how you interview people who've been through something traumatic is difficult, and particularly if you've got especially vulnerable witnesses, for example, children. There's another issue that you need to take into account, particularly when working with witnesses, is the issue of interpretation and translation. It would be ridiculous to adopt a rule that you will never work with a translator from the place in question, because in that case you couldn't go fact-finding in some of the places with really esoteric languages. You've got to find some other way of gauging the quality of the interpretation and not being hesitant to change interpreters if you've got any suspicions on that score, although it can then jeopardize new interpreters, and I've got examples of that happening. But you also need an interpreter, not just literally to tell you what somebody said, but possibly to explain the cultural ramifications of what was said. It's not simply a technical process. And you do need to face the fact that you can't be purist in an armed conflict. The people who have seen most are, oddly enough, the fighters. You can't say, oh, they're bad guys, they're members of an organised armed group belonging to a non-state party, can't ask them anything. Because they're the ones who've seen it. The civilians usually have got enough sense to be tucked away in a cellar somewhere. So, of course, you need to handle their evidence with care, but that doesn't mean that you have to disregard their evidence. The evidence of civilians from war zones can be adversely affected by all sorts of things. They may be in an area controlled by a particular group, even if members of that group aren't in the room. They may have an intimidatory influence. But that doesn't mean that when they say that X happened, they are necessarily lying. So you can't simply say, well, we will exclude all that evidence. Sometimes it's not even anything that the organised armed group wants to do, all on their own. They can have either the view that there's certain things I mustn't say, or they want to improve the evidence. I've had the mother of a guy who was shot dead by Turkish security forces in a situation in which the European Court of Human Rights ruled there were no grounds for opening fire, let alone that it was disproportionate. And in that situation, I was trying to find out whether weapons could have been planted in the place in question. And the mother said, oh, well, if there weren't weapons there, they would have wanted them to be. Well, when you've got mothers, little old ladies, coming up with attempts to get their kids made into martyrs, even if they might not have wanted it themselves or been martyrs objectively, if that makes sense, then you've clearly got a complication where you need to filter out. But you don't filter out everything. You can't have a rigid rule. Judges are very used to this. It's an issue of individual credibility. And in my experience, slightly to my surprise, the European members of the European Commission of Human Rights have no difficulty at all in distinguishing between a person who was giving clear factual answers to factual questions and lying through his back teeth, and uneducated peasants who weren't able to give accurate figures. They weren't, I mean, the women were for the most part completely unschooled. They couldn't count accurately above 10. 20 meant a lot, 100 meant a lot, a really lot, and 1,000,000 meant a huge number. It didn't mean 1,000,000. And the Commission had no problem in recognising what they were getting at. Even though if you applied a very superficial criterion, you might have thought that the evidence from the gendarme was more credible. So that, I think, one can rely on a certain measure of common sense. It is a difficult issue, but you mustn't simply exclude the evidence of all civilians, for example, in southern Lebanon on the grounds they're frightened by Hezbollah. Let's exclude all evidence from any member of Hezbollah because he's a member of Hezbollah, therefore he's going to lie through his back teeth. It's more complicated than that. You've also got a strange phenomenon. I think it seems to be the way that villages work. And not necessarily if they're where you're very remote, but I think it's to do with village life and remoteness. You sometimes get what I call a collective village memory. It doesn't mean you're lying. It means that people are used to a communal living and to a communal system of recollection. So after an incident, they all end up, if you like, with the same story. They're not inventing it. They've just put together everybody's evidence. Now that was a challenge in the Turkish litigation. What we had to do each time was to say, what did you see with your own eyes? To actually distinguish what that person had seen from what the village as a whole had recollected. There are also issues, particularly if you're trying to fact-find fast, with regard to access to and interpretation of technical evidence. Things like cockpit videos, you probably aren't going to get them fast. Possibly medical evidence, you're not going to get that fast. There are big problems with this kind of, at least with cockpit videos and any other form of video, and that's checking to make sure it's not being doctored, because either side is equally capable in this day and age, particularly if they've got youngsters involved, of doctoring things like videos. So there are real practical challenges when fact-finding in situations of conflict. It's even more difficult than ordinary fact-finding. There are difficulties both if you're fact-finding during and fact-finding after, because the issues that, I mean, if people are willing to fight over an issue, they're willing to lie about an issue. And therefore it's not an answer to say, oh, well, once the fighting is over, it should be straightforward. It's not going to be straightforward because of the nature of the situation. And on top of that, you've got the complication of the law that I referred to earlier. So my final point is, what can we look for going forward? Because there clearly are problems with some NGO practices. Can we look for rules, guidelines, minimum standards, anything like that? I think they can certainly be called on to do their best. I think they do try to do their best. I think they can be asked in any publication to identify the functions of the publication. Is it simply to alert people, or is it a considered response? They can be asked to identify those who took part in its drafting, but not the witnesses, except in exceptional circumstances. They can be asked to identify the time frame that it addresses, the geographical scope of the report, and the time frame within which it was produced. They can be asked to give some information on methodology, but there's a really interesting example in the book, which is why I think you ought to buy the book, and if you can't afford to buy it, rent it. And that's how Zimbabwe reacted to a report. Sometimes the danger of explaining your methodology is then the state can always criticise the methodology and seek to undermine the report. There has never been an investigation, whether it's an investigation carried out by a state into an alleged violation or fact-finding, where you can't make some criticism of the methodology. And there's a risk that you're going to divert the attention from that which is being examined to the means by which it was examined. So I'm not certain to what extent it makes sense for the NGO to address its methodology in a specific report. What it maybe could usefully do is address generally, say on its website, how it carries out fact-finding, rather than making it report-specific. And clearly they need to be in a position to justify themselves on reports if challenged, but I don't think you can, I think there are problems if you require them to do it in each report. I think they need to submit reports, even ones where they're trying to go for speed, unless in the case of speed they make it clear they've not consulted the government, that they should seek to get a response from the government whose conduct is being examined. But again, you can see from in the book the example of Zimbabwe that can lead to problems. I still think it's worth, when it's a considered report, getting input from the government. Where I do think they should be urged, and it's generally in their interest to get this right, urged to make changes, is how they express their conclusions. In other words, it makes a huge difference whether they say, we have concerns about, or this was a war crime, this was a crime against humanity. And at the moment, they're simply getting things wrong when they don't give you the evidentiary basis on which you can reach that kind of conclusion. It's in their interests, because if they are more cautious with the language that they use, they're more likely to be seen as credible. And for many of the NGOs, particularly Amnesty and Human Rights Watch, their credibility with third state matters to them. So I do think that in that regard, and that's something they can do straight away without any sort of negotiation of anything, I think that there is a basis for discussion with NGOs. I think it would be worth not threatening them with things like guidelines or minimum standards or rules, but simply let's see if we can have a discussion on how to improve, without suggesting that what's going on is currently bad, how to improve and make better current fact-finding practice, whilst making it clear that it's recognised that they're fact-finding in extremely difficult situations, and that there's never going to be a perfect fact-finding report. Do remember, courts don't aspire to find the truth. They simply aspire to finding the most plausible account of the facts. You can hardly expect NGOs, or the fraction of the resources of states, to come up with truth. What you can ask them to do is their very best effort in good faith, taking account of common sense concerns about the quality of the evidence they're handling, and you can expect them to do it reasonably. I think they would be happy to participate in that kind of discussion. I don't think they'd be happy if they felt a big stick was being wielded over them. So I think there is a way forward, but you need to take the NGOs with you, and that means discussion. Thank you.